Apologies, my network dropped me off. I hope I'm audible. So, as we were considering the differences between international law and public international law and private international law, we talked about scope, we talked about subject matter and governing law. We're now heading into compliance. So compliance, as far as public international law is concerned, relies on consent and voluntary participation of states, diplomatic negotiations, economic sanctions, and the jurisdiction of the international courts and tribunals. Compliance, with regards to private international law, does not involve enforcement mechanisms per se, guides courts in different jurisdictions in determining the appropriate legal rules to apply in cases involving international elements, so international foreign elements. So here we're basically saying that as far as enforcement is concerned, as far as the pursuit of enforcing principles is concerned, for international law, we rely on the basics of consent. You can't bring a matter against the state if the state has not consented to that particular dispute. That's how it is in international public international law generally. But for private international law, it is not necessarily dealing with mechanisms. It deals with guiding the court with regards to jurisdiction in determining the appropriate legal rules to apply in specific cases. And the last consideration is the impact on individuals. Now, there is no direct link as far as public international law is concerned to individuals. Public international laws treat individuals to have what is known as a passive personality. That is, they only enjoy the benefits of international law and will only have obligations, maybe with respect to human rights and humanitarian law. There is no direct standing which relates to individuals in public international law. But private international law, because of its very nature, directly deals with individuals because these are private entities. These are the entities that are consistently engaging in contracts, in commercial transactions, in tortious actions, in the purchasing of property, in things like marriages. These are the private individuals who are involved in these activities. That's the regulation that private international law has is for specifically individuals, of course, individuals and corporations and partnerships, and those persons who are considered to be under private international law. Now, with those differences considered, we can now go into our next slide, which is talking to the basis for conflict of laws, or the three pillars of conflict of laws. There are three significant pillars that are considered whenever a conflict of laws is being considered. So this can also be called the justification for conflict of laws. Why do we have conflict of laws? There are three things that come up. There's justice, there's public policy, and there's comity. With regards to justice, we are basically talking about the interest of parties being served. And I said earlier on that conflict of laws ensures that the interest of the person is, in fact, served. The promotion of principles of fairness and equality in relation to interest are cardinal considerations for conflict of laws. So for the pursuit of justice, conflict of laws is created. So it is based off the promotion of justice in every situation. And you can consider the case of Bonacina, 1912, as a case to use to justify the fact that justice is a principle upon which conflict of laws is founded on. Then we have public policy. So if the non-determination of the matter is going to lead to the promotion of indecency, the promotion of factors that affect the public interest, conflict of law rules are going to be applied. Public policy or the interest of the public is in fact at the heart of conflict of laws. That's why Scarman J stated in the Estate of Feud case that an English court would refuse to apply a law which outrages its sense of justice or decency. But before it exercises such power, it must consider the relevant foreign law as a whole. So instead of just deciding the matter, there is need for the courts to consider the issues of decency, which is part and parcel of public policy, or public interest as a whole should in fact be taken into consideration before a determination is made. If you look at the case of in the Estate of Feud, 1968, you're going to appreciate that public policy in fact forms part of the heart of conflict of laws, or part of the foundation of conflict of laws. Then we have the principle of comity. Comity relates to reciprocity. It basically is issues of courtesy. So when you say the principle of comity, you're talking about the principle of courtesy. Now, the principle of courtesy is now embodied in law. So here we're saying states who apply conflict of law rules or foreign laws in determining their matter in expectation that the similar treatment, if it so happens in this particular country where the law they've used to determine the matter is what is dealing with such a situation, they equally apply the same treatment to persons who are protected under their legal system. So, for example, we have a marriage in consideration where a Zambian is being married to a Congolese. If the matter is brought before the Congolese court in determination as to whether or not the marriage is valid, and the Congolese court decides the matter as if it was a Zambian court, the principle of comity comes in there to place about expectations that in a situation where a Congolese couple or a Congolese and a Zambian couple equally before a Zambian court, and the Zambian court is considering whether or not there's a valid marriage, the equal treatment that was made to that particular to the earlier case is equally going to apply it in the latter case, whereby Congolese laws are equally going to be applied by the Zambian courts in determining issues of valid contraction of a marriage. So this is what comity is about. It is about courtesy, reciprocal treatment. If I do this, I'm expecting that you will also do it. So that is comity. Now you can look at the case of Sotomayor versus DeBalos, 1877, as the authority for comity as a pillar of conflict of laws. So that is, those are the three pillars, or rather the basis for the formation of conflict of laws. Do not forget. If you're talking about the basis for conflict of laws, always talk about justice, always talk about public policy, and talk about the doctrine of comity. So in determining the matter, this the principles rather that are always taken into consideration as far as conflict of laws is concerned. One such principles, or rather one such directions, are called connecting factors. These relate to the facts that tend to connect a transaction or occurrence with a particular law or jurisdiction. Connecting factors are considered by the courts of law in order to help them determine what issues are to be decided by the courts of law in order for them to resolve the dispute, and so on and so forth. So there are various Latin maxims, as you are seeing right now on your screen, that are considered to be part and parcel of what we're calling connecting factors. We have lex causa, which basically means the law which governs an issue. We have lex actus, the law governing a transaction, such as an applicable law of a contract. We have the applicable law of the contract. We have lex domicili, which is the law of a person's domicile. Then we have lex foli, which is the law administered by the courts here in the case. So this is the law of the place where the court is established. Then we have lex loci actus, talking to the law of the place where the transaction is concluded. We have lex loci delicti commissi, the law of the place where a tort is committed. We have lex loci solutionis, the law of the place where the contract is performed, and the lex situs, which is the law of the place where the property is situated. The connecting factors here that I've mentioned are going to form independent topics on their own. So things like lex loci delicti commissi is going to be part and parcel of the law of contract. Lex loci solutionis and lex loci actus is going to be considered under the law of contract. We have lex fori, which is going to be considered under jurisdiction as a topic, and so on and so forth. We've already we're going to consider rather lex domicili as in relation to the law of domicile. So each of these are going to form independent topics. This is what I was referring to when I was talking about the choice of laws as the second branch of conflict of laws. So all of these are now going to be further explored to see how they are operational, how they aid the court in determining the matter. They are connecting factors and they form part of the choice of laws as we know and appreciate. Then we have the principle of characterization. Now, the principle of characterization, in summary, basically means that the courts are taking into consideration what issues exactly are to be determined in the matter. So it is not every case that has the same principles being considered. We might be considering a contract, but the issues that are to be determined by the courts themselves with regards to the contract are all founded through this process that we're calling characterization. So it refers to the process of classifying, qualifying, and interpreting laws that apply to a specific legal case. So it is not necessarily dealing with the whole topic. Conflict of laws does not deal with the whole topic or the whole area of consideration. It deals with specific issues. So in order for us to arrive at this particular specific issue, the court goes through what is known as characterization or classification. So the classification can be a classification of an issue, classification of the laws, classification of the route to take. That can only be founded if you're taken into consideration the principle of characterization or the doctrine of characterization. Now, we have a very important case here, Recon, 1945. In Recon, what happened was there was a daughter and a mother who was on board a plane, and they drew up wills separately. So in their wills, they each left property to the other in case they precede the other. So in the daughter's will, it was indicated that all of her property will be transferred to the mother if she dies before the mother. And in the mother's will, it was decided that all her properties all of her properties will move to the daughter if she dies before the daughter. Now, they were on board a plane and they unfortunately encountered a plane crash and they both died. So now the determination of who was going to inherit the property came before the courts of law, and the courts did not consider issues of inheritance outside the wills, because the wills dictated who was to gain the property. But further to that, the daughter's will indicated that in cases where the mother had passed on, our properties are going to be transferred to in portions, of course, to our siblings, our husband, and our children. So now the court had to determine what was their domicile when the plane crashed. What was their domicile, and what were the rules relating to the wills as far as inheritance of property was concerned. Now, the courts, when the court was determining recon, they established, or rather they characterized the issue of who dies first. Okay, who dies first. Of course, it is illogical to think about who died first in a plane crash, because it can be considered that both of them died at the very same time. But the court characterized the issue and in fact came up with the principle that in situations where death happens at the same time and immediately, the older person will be considered to be the one who has died first. So they used age as a determining factor to state who, in fact, passed on first, and thus determining how the wills were going to be given life. So since the mother died first, all our property moved to the daughter, and the daughter died then, so all our properties now were left to the husband, the siblings, and the children, since our will equally provided for that. So that is recon, showing you how classification is done, characterization is done in relation to conflict of laws. Have a look at that particular case. It is a very interesting case. When you read it, you're going to see how characterization is actually done. You find things like the connecting factors, what is the applicable law, what is the issue that is before the courts of law. All of that is done through characterization. Then we have a very important doctrine, the doctrine of renvoi. The doctrine of renvoi is part and parcel of conflict of laws, and it is one that you cannot go without. So renvoi in French basically means to refer. So the doctrine is basically a process in itself, and it relates to a technique that is adopted by a court of law to refer or consult the laws of another state or country in order to determine a matter, or merely determining a matter as it would have been determined by another court in the same circumstances. So remember the principle of comity, it comes at play using the doctrine of renvoi. So renvoi will usually be considered in situations where the court are faced with a conundrum, and instead of applying their own laws, since the laws might lead to an absurdity, they will refer to the conflict of law rules of another country, which is brought to light due to the foreign element. So this is what we're referring to as renvoi. So it is a technique that is applied by the courts of law. They will consult the laws of another state, the conflict of law rules first, and from there, from the consultation of the laws, the courts will make its determination. So that is the doctrine of renvoi. There are 4 types of renvois. There's single or partial renvoi, there's double or total renvoi, there's a remission, and there is a transmission. Don't forget that. Single or partial renvoi, double or total renvoi, remissions, and transmissions. That is what is considered to be, those are what are considered to be the types of renvois. So we can start with single or partial renvoi. So if you're applying single or partial renvoi, what it basically means is that the court is referring to the conflict of law rules of another country, and the rules in the country that they have referred to directs the court that in such a situation, they are supposed to apply the laws that are existing in their own countries. So, for example, A refers to the conflict of law rules at B. The rules at B instructs the courts at A to just apply the law's existence in the forum. Then that is going to be considered a single or partial renvoi. You can consider the case of Riros, 1930, which talks to this situation. So in a circumstance where a reference has been made from one country to another, and the laws, the conflict of law rules, of course, remember, we're not consulting the domestic laws of the country, but we're consulting firstly the conflict of law rules, which will then direct to what the applicable law is. So you consult the conflict of law rules of another country, and the conflict of law rules in that particular country directs you on what law you're supposed to apply in order for you to resolve the matter. So in a situation where Zambia makes reference to the conflict of law rules in Congo, and the conflict of law rules in Congo inform the Zambian courts that in the situation that they found themselves in, it is better to just apply the laws of the forum, that is Zambian law, then that is going to be considered a single or partial renvoi. Then we have double or total renvoi. For double and total renvoi, reference is made to another country's laws, and that the rules in that particular country, the conflict of law rules in that country, instructs the courts to apply the laws of the referred to country. Then that is considered to be double or total renvoi. There is a reference that is made first, then the reference is made to the conflict of law rules, and the conflict of law rules in that country instructs the courts to apply the laws of the country that they've referred to. that is considered double or total renvoi. For example, a country A, which is Zambia, for example, Zambia makes reference to Zimbabwean conflict of law rules, and the conflict of law rules in Zimbabwe instructs the Zambian courts that in this particular situation, it is best to apply Zimbabwean law in determining the matter. Then the Zambian courts apply Zimbabwean law and decide the matter as if it was a Zimbabwean court. Then that is what we're referring to as double or total renvoi. And you can look at the case of Annesley 1926 to help guide you as far as double or total renvoi is concerned. Then we have a remission and a transmission. So these two will usually come about in circumstances where there has been more than one reference that is made. So for example, in a remission, country makes a reference to the conflict of law rules of another country, and that country equally directs them to look at or to consult the conflict of laws of law rules of another country. Then that other country that they've made reference to directs the court that in a situation where you've made a reference to this point and it has referred you to us, merely apply your own laws. That's what we're calling a remission. So I usually call this back to default settings. So references have been made in more than one country, and the rules at whatever point whatever point they make a consideration, whether it is at number 4, at number 3, that particular country informs the consulting court to apply its own laws, then that is what we're calling a remission. So, pardon me, back to default settings. Then a transmission. In a transmission, reference is made from one point to another. Okay, so country A makes reference to country B. Then country B's laws indicate that in a situation that you found yourself in, it is better to apply the laws of country C. Then that's what we're calling a transmission. So not applying the laws at A, not applying the laws at B, but apply the laws at C. That is what we're calling a transmission. Okay, so we have a single and partial renvoi, double or total renvoi, and we have remissions and transmissions. For the latter two, you're considering more than 2 countries. For the first two, you're considering just 2 countries. It will help you, and so that you are equally not confused when you're explaining renvoi and the types of renvoi. Then we have pros and cons of renvoi, that is advantages and disadvantages. There are more, but these are the main advantages and disadvantages. For the advantages, it provides for consistency and avoids forum shopping. So if you are relying on the doctrine of renvoi, you would prevent forum shopping. So forum shopping basically means a state, or rather a party, going to a more favorable country where they know that they're going to receive favorable treatment. So that is going to be avoided if renvoi is applied, because it ensures that a similar law is applied regardless of where the case is being managed. So in a situation where Zambia is the one that is handling the case, then renvoi is applied. Maybe the situation is reference to a Zambian and an English woman, then reference is made to the laws in England or to the laws of whatever area that they contracted the marriage at. Even in a situation where the case is before maybe a Congolese court, the same principle is going to be referred to, and reference is going to be made to the same countries. Thus, provided for consistency and, in fact, avoiding forum shopping as a whole. And it allows for the application of domestic law of a foreign country, which may be more appropriate in certain cases. So in most cases, or in certain cases, in fact, where renvoi is applied, the domestic laws of the country or the court handling the matter might not be the most appropriate laws to be applied to the case at hand. Thus, the application of foreign law can be more favorable, or rather can be for the promotion of justice, public policy, and comity in the situation that the case is has found itself in. So it is used to, in fact, ensure that foreign law is applied, and that law is applied to the benefit of the parties. Then the disadvantages is that it may defeat the reasonable expectation of the parties by applying a different law when they expect it. So, of course, in most situations, especially with the application of principles such as stare decisis, there's a reasonable expectation of people who are involved in a case, whereby they expect an outcome to be of a particular nature. But in a situation where renvoi is applied, of course, this expectation is going to be waived. So reasonable expectation is not going to be allowed in that regard. Then it can also be impractical and difficult to apply in certain cases. For example, if maybe the conflict of law rules in your country refers you to a different legal system. For example, you're in a Commonwealth system, and then it refers you to maybe a federal system. So it might be difficult for you to apply the laws in a federal system here in a Commonwealth country. For example, here in Zambia, where we don't consider issues of gays and lesbians. So in a situation relating to property distribution after marriage, and this particular couple is one that is one that is homosexual, it is going to be difficult or impractical for us to apply the laws in the States, for example, where they contracted a marriage so as to resolve the matter. So it's very, very at times it's quite impractical and difficult to use. Then we have issues of uncertainty and confusion. Because of its very nature, it may lead to a lot of uncertainty and confusion as to which law to apply. So you might find that you are being made quite a number of reference for you. So you've made the reference to country A, directs you to B, directs you to Z, directs you to that, and then all of that. And then in all of that situation, you'd find that one of the countries just say, apply the laws of all the other states that you've made reference to. So that becomes confusing, and there's a lot of uncertainty with regards to the application of the law. Then other than that, it is also lengthy, which causes the whole process of adjudication to be costly, an issue that should not even come up with regards to adjudication. So those are some of the advantages and the disadvantages of the doctrine of renvoi. So in this particular recording, we've discussed issues related to the foundation of the course. We've talked about the introduction to conflict of law rules, what conflict of laws rather, what it means, what is a foreign element. We've talked about the differences between public international law and private international law as part of the bigger course of international law itself. So international law is made up of public and private international law, if you're considering from an academic perspective. So that is public and private international law. We've tried to distinguish what is what exactly. Then we've gone into looking into connecting factors. We've looked at the various Latin maxims that are used in deciding the choice of law or the applicable issues here. Then we've talked about characterization. We've finally ended the lesson with talking about the doctrine of renvoi, its advantages and its disadvantages, as we have discussed in this course. So this particular recording of the class has finally come to an end. And as is always the case with questions or anything of that particular nature, you are free to contact me using that particular email or post in the group. You can post in the group your questions and anything that is of that particular nature. So with that, shalom, and in fact, do your reading for the cases. Thank you so much. The islands will know, the islands will know, the islands will know your justice.